Okay, so again, thank you for coming. So what we're going to do now is open up the floor for questions. So for the, I guess, third time, I'm going to introduce the panel. So to my far right, we have Professor Kathy Strandberg from NYU. To her left, we have Professor Mark Janis from IU Bloomington. To my immediate left, we have Professor Craig Nard from Case Western, and to his left, we have Professor Tim Holbrook from Emory. So these scholars, they write in patent law, they also write and teach in other areas of IP. They're all prolific. They've written case books, lots of law review articles, and they've also practiced, clerked, so on and so forth. So now is the time to ask them any questions. So should I go into prosecution or litigation? Should I clerk or not? What are the hot issues in the federal circuit? Should we issue patents on genes, or whatever you want to ask? Now is the time. So yeah, just raise your hand and I'll identify you. And if you want to direct your question to a specific person, that's fine, or we'll just do a free-for-all and let whoever wants to answer it, answer it.
I know that some of you guys have clerked for the federal level, the federal court of appeals level. What's the value of a district court level for practicing the patent litigation or prosecution in the future compared to the court of appeals level?
You know, I haven't done a district court clerkship, just I was at the federal circuit. But friends of mine who were at the federal circuit coming from a district court clerkship thought the experience was invaluable because there you see the action, all the pleadings, all the battles, the settlement conferences, the sort of nuts and bolts. You know, you win your case at the district court level, more or less, right? So that experience, I think, would be extraordinary to have, and you could just stop right there or go on to an appellate clerkship. But I would encourage it very strongly.
And two thoughts on that. One is if you can get a clerkship in the area you think you're going to practice, a huge bonus, right? Incredibly beneficial to be able to know. Yeah, exactly. And then if you are interested in patents, if there's you can get to a judge who does a lot of the patent stuff, again, the process of going through a patent trial or marking hearing incredibly valuable for your firm, for you. That being said, just any judicial clerkship is incredibly valuable and worthwhile. But I think the district court clerkships, they're very different and in a very good way. That you really do, as Professor Nard said, get into what is going on. You actually interact with the parties, right? Whereas I clerked at the federal circuit as well, we weren't allowed to deal with the parties. We were walled off. So it's a very, very different experience. And I somewhat regret having not had the chance to clerk in the district court.
Getting the federal circuit clerkship is, like getting a lottery ticket. So, I've had students do this before, tried for it, didn't get it, and now got district court clerkship, and it really helped them then turn around to get a federal circuit clerkship. Really helped. So,
I would also say for federal circuit clerkship, not only is the district court clerkship helpful, but 2 to 3 years of experience in practice. Some judges look for that as a big plus, because their education costs for going in. It's such a specialized area. You'll come and hit the ground running, so to speak.
And I think just to add to that, I think that firms, from having done litigation, I think firms really value the district court clerkships exactly because it gives you that kind of head start in terms of understanding, having a clue about what's going on practically, because that's really where most of the work is going on, is the district court cases. So I think it's very valuable. I think both kinds of clerkships are very valuable. And I did not do a federal circuit clerkship. I did a Seventh Circuit clerkship, and that was also very valuable. So any clerkship is valuable.
How'd your hand up?
Yeah, I did. I was wondering if you guys could talk about patent issues in your scholarly work versus in practice, and whether you think those correlate or whether you think that they don't.
Yeah, that's.
you studied that really well. Greg studied how often federal circuit say to yourself, why do I want to read some theoretical thing published in the Yale Law Journal about patents? At the very least, you want to know that this debate is going on, because people who write this stuff, we do file amicus briefs, and we might affect the litigation. So I think that, taking the extreme examples, or even the paper that we look at and think, theory stuff, what would it ever have to do with reality? Actually, there might be something that you would at least want to know about. I feel like I'm constantly preaching that to my students. At least understand that this scholarly exercise is going on, even if you're just reading abstracts and going, I'm never going to use that. At least you know what's going on. And then, just to bring it back together a little bit, I actually think there's a little more crossover than those comments imply. I think a lot of us, especially patent law, do have kind of a practice orientation or clerkship orientation, and we've got a court to speak to, the Federal Circuit, and I tend to think that a lot of scholarship in that area actually does have a nexus to the real world.
I was going to agree that I don't think the divide is quite as wide in patent law than, say, con law or some of the other areas. I think in part because the theory of patents drives a lot of the doctrine anyway, so it's not so far removed. And I think that's also supported by the rather skeletal structure of the Patent Act, that is common law driven, and when you have common law driven things, the theory, the policies can come into play a bit more. And I think most pieces, I don't know, the way I write, I always view, like, there's the theoretical part that I'm offering, which I know is severable, but there's almost always a discussion, a doctrinal discussion, or some other discussion of what the law is and what it should be, that you can get value from that as a practitioner, practical level. And then you sort of like going, that's the wacky theoretical part that I can just sort of either skim through or ignore, right? And I think most articles are written from that perspective.
And historically, the scholarship enterprise was designed to inform your teaching. And we moved away from that as a legal academy and just talk to each other, which is unfortunate, certainly in some disciplines like con law. I do agree that the patent law is not like that. And so I think the best pieces, if Tim, Kathy, or Mark, Sean, Dan, they write something, I'm going to read it because I know it's going to blend practice and theory in a way that makes a lot of sense. What we want to do is we want to have somebody read our work and affect change positively. You don't do that by talking to just a couple of people. And I think patent law always has that sort of instrumental endpoint in mind, maybe more so than other disciplines.
And maybe I would just add that I also do think that scholarship is sometimes related to what goes on in a rather indirect way. And so I think there is value in simply doing the theoretical part, even if it doesn't have any kind of immediate impact. Whether as practitioners you guys need to read those more theoretical pieces, maybe not, But I think that what happens is these things become part of the debate and part of the discussion, and eventually, at least sometimes, they make their way down into what's going on in the courts. And also just to point out that a lot of us are engaged in practice-oriented things where we are trying to bring our theoretical thinking into practice. Everybody here's written amicus briefs, is that right? Law professor amicus briefs, so we all do that, right? And we do other things like go speak to practitioners and so forth. So there's a fair amount of give and take. But I also think there's room for the kind of real ivory tower stuff as well. I'm a fan of that too.
To steer your question, Professor Seymour, should genes be patented, and if so, should there be limitations?
No. I'm not in the camp.
No to limitations, or
No gene patents, no limitation. No, I am sorry. I've publicly written that. I think that the patenting of human genes, it's too far upstream, it creates too many opportunities for blocking downstream innovations in research. I don't think that the patent incentive really drives the discovery of genes, and there's lots of other people who do research into genes and genetic code that you don't need the patent to incentivize. That being said, the myriad of cases floating out there, I do think that my interesting to see what they say. There's also a huge standing issue about what's going to happen in that case. But I have never been a proponent of gene patentation. I don't think it's necessary. I don't think biotech world's going to collapse and we're suddenly going to lose all of our innovation in genetic technology because you can't patent opportunity.
I think one way to frame this issue is to view this on a continuum where you have the upstream discovery, as Tim suggests for gene discovery. It's somewhere on that continuum, if you're talking about going down to a drug, a patent has to intervene somewhere. And the debate is where exactly should it intervene, because at some point you're going to need larger players to take it through the FDA if you do need FDA approval. So Pfizer wants to make sure Merck can't play in the same sandbox. And one way you do that is to have a patent. So the question is, where do patents make the most sense? And that's an empirical question. The issue of blocking and upstream blocking, that's a real mixed bag, right? It goes both ways. There's evidence both ways there. The pure legal question, does the statutory subject matter code allow for gene patents? I think that's also mixed bag. You can make arguments both ways. You can say, well, I'm just going to err on the side of settled expectations. We've been doing it, let's keep doing it, and not be disruptive. Or as Tim suggested, if you do say these things aren't patentable, I think it's really going to change that much. And I think, Tim's probably right, that's probably not.
It's another sort of angle on it is to see this within the fabric of eligibility jurisprudence generally. And what concerns me about a number of these cases is not really the particular question on the merits, as you guys have been discussing. What concerns me is a move toward trying to use restrictive eligibility doctrines as a policy tool, which I think is going to turn out in the long term to be a failure, just from looking at, 20, 30 years of software eligibility jurisprudence. I would be led to say it really doesn't work. People claim around the eligibility restriction. There's a lot of, again, ancillary litigation. There's a lot of litigation over what's meant by math, what's meant by, and these profound what is nature. I'd rather see a lot of that sort of effort be put into developing good enablement filters, developing good obviousness filters, and I'd rather not see courts placing a lot of faith in eligibility restrictions through this kind of filtering. I also agree with Tim mentioned that there's a procedural issue in Myriad that I think it's very important to ask what mechanisms should we really have to permit validity challenges, and how far do we want to go from the standard, you could sue for infringement, so therefore clearly, there's controversy. We're trying all sorts of different things. There's pending post-grant review legislation, the patent reform legislation, and I think some of this seems inconsistent to me, and I think that that procedural issue actually is really important in the long term. It could affect a lot more cases than just, this 2000 years.
Maybe I'll put, since I don't agree about the importance of the patentable subject matter eligibility, I'll chime in. Also with a certain amount of disclosure, which is that I am, speaking of amicus brief writing, I am representing some of the medical associations that are involved as plaintiffs in the Myriad case, not in that case, but in, I think, somewhat related, as amicus, in somewhat related litigation in the Prometheus versus Mayo case. That said, I only take amicus cases that I agree with, so, that's part of being an academic, you can do that. So I think the problem with saying, let's just let obviousness and all the other doctrines take care of patent eligibility, I think is really brought into focus by the kinds of cases that, to some extent, Myriad and also this Prometheus versus Mayo case are, which are cases where patentability bumps up against science. And I used to be a scientist, so I have also a lot of strong feelings about science. And we've always had, traditionally, this patent subject matter exception for products of nature and scientific principles or principles of nature. And I think that it's very important to keep those in the non-patentable realm for for some of the reasons that Tim already mentioned. And also because many of these things are simply, they don't need the patent incentive. We have a whole sort of scientific research system which is set up, which gives lots of incentives for discovering new scientific principles, and also, more pertinent to the gene patent issue, inventing new research tools. So I think we need that line. I agree that it's hard to draw, but I think we need it, so I think we have to draw it. I would say also, though, that another way to deal with some of these issues, which my colleague Rochelle Dreyfus has been very involved in, is to do it on the exemption side, to beef up our research exemptions. And I still think probably that's not enough, and I think the Prometheus type case, which has to do with the patentability of a medical procedure, which is essentially saying, look at the statistical correlation, and then, change the dosage of medication depending on a statistical correlation. So it's basically observe what's going on and then do what would be obvious when seeing that. Perhaps, well, yeah, but maybe not obvious in the, in the legal sense. So, I don't think we need, I think that there's some things we should just say, this is just not patentable, and we don't need to get into whether or not it's obvious. Because maybe it's a brand new discovery. These statistical correlations are newly discovered. I don't think that makes them patentable. So I think the research exemption possibility is important, should be expanded, but I'm nervous about thinking that it will totally take care of this science-technology divide.
Other questions?
I have a question for the panel. The purpose of patent law, of course, is to encourage innovation. But on the other hand, a too low standard, a very low standard of patentability may end up suppressing further innovation. So in your opinion, what should the U.S. Patent Office do differently to further promote innovation?
Great question. I'm gonna take a bite here. Look, I think you've identified, one of the central purposes of a patent system is to promote innovation, right? What does that mean? What is the job of the patent office? What's the job of the courts and other institutional players in this space? I think everybody wants the patent office not to issue patents on things that aren't novel or obvious, right? You want the patent to be a really good filter. And so how do you do that? I mean, if you want to put your cost on the administrative side rather than on the court, so the patent office can just issue everything, and then you could say, well, only the commercially valuable patent will be litigated, therefore, let's just rely on the courts. That's one view. The other view is put a lot of money in the patent office, restructure it, and have various filters to prevent bad stuff from issuing. So this has been a debate for some time, right? So you could have opposition proceedings, you could have the gold standard, like super duper examination. It all depends on where you want to spend your money and resources. And there are various views on that. I happen to think that having a really good filter up front makes a lot of sense. Because if you just have a weak patent, you can use it as a hammer because litigation costs are so high, and you have uneven bargaining power. I'm going to take a license and try to fight this thing, even though that patent is probably invalid. So I want to prevent that from issuing in the first instance.
I'll give you elliptical answers since I'm not leading the one, which is just that in concept, I think the idea of a patent system is ingenious, totally ingenious, to draw private investment by granting a property right rather than trying to figure out the right level of correct substance. Having said that, I think that, centuries have proven that as ingenious as it is, it's very difficult to implement. And that practice of implementation, I think, is just an ongoing experiment. So we could give you the perfect answer today, be totally wrong in 10 years because technology is going to change, administrative practice is going to change, litigation dynamics may change, and all of these things influence how much money you want to put into the patent office as an institution as opposed to other institutions in the system. And indeed, how you want to design them, specialized court, non-specialized court, and so forth. So I guess I'm not solving the problem or really answering your question directly. I'm just saying that that's such a difficult question that I think the best that we can expect is, we try something, we experiment, then we have to tweak, and then we have to try something else, and then we have to continue to tweak and continue to tweak and continue to pay attention to these inter-institutional dynamics.
I tend to agree with Professor Nard that I'd like to see it at the patent office. There's been a lot of statistical analysis of what are the issuance rates, and it dropped off for a while, and the patent bar got up in arms, saying it was too hard to get a patent, went back up. It sort of begs the question if there is an optimal patent grant rate, right? There's a certain normative judgment in here about how much innovation should be enough under the obviousness standard. What is the appropriate grant rate to the patent office? My thought on that is I would rather see the patent office err on denying patents, which makes all the patent owners scream. But the reason isn't that I think that we should just not have patents. It's twofold. One, there's so many procedural mechanisms that allow the patent applicant to try and keep going at it that I'm not terribly upset if they are denied patents, that the application is denied first. Second, that's the only way to get these applications into the court system, right? If the patent office errs on the side of granting things, then there's never an opportunity for judicial review, right? If the State Street case came up through litigation, which meant the patent office had already changed its stance on business methods back then, right? And so suddenly, if the Federal Circuit, now apparently we have shifted a little late, right? The courts changed it at that point. You've got lots of patents out there that have issued under what was seemingly an improper standard. So for me, there's a change that the PTO should have, and be a presumption against the issuance to try and force these things to be clarified by the Federal Circuit and the courts a little bit more quickly.
Is that how you implement that, Tim? I was sitting here thinking, that sounds great to me. How would you do it? Would it be by virtue of changing burdens and presumptions? Would it be by changing substantive standards?
Well, because that's the other issue, right? The patent office can't technically change the substantive standards.
No, not on our own. We could do it.
We can do it, yeah. I mean, and I got asked that once. I'm not quite comfortable saying I want the patent office to do that quite yet because I'm concerned about capture issues, right? We give them the ability to set substantive standards. I'm not convinced it would be in the direction that might be actually optimal for society. But I do think if we shift presumptions, right, in essence now, the presumption is you get it in some regards, right? It's the examiner has to come forward with some of this evidence, and they're clearly not in a position to do a lot of great examination. So I think if you can shift the presumptions around a little bit more. Is it more costly up front? Yes. I don't think that's bad, right? If you think about raising the cost, then that should knock off some of these poor inventions that shouldn't be getting applications filed anyway. It's like a tax, right? You raise the tax, people aren't going to do quite as much as the junk patent. So I'm not concerned with driving up the upfront cost quite as well.
Just maybe I'll add one thing on that, which is that, and I don't have an answer to this, but I think that one of the things we should continue to think about how to do and work on different approaches to doing it is to get the patent office more connected to the knowledge that is out there among the people having ordinary skill in the art. And there's been a kind of experiment going on with doing this something called the peer patent system, trying to get people to submit prior art. There's the idea of making it more attractive to companies to push for re-examination, or maybe have new procedures for doing that. I mean, I think all of those things are worth exploring and thinking about, because one of the biggest problems of why do these patents get out there in the first place is that the patent examiner doesn't have easy access, despite perhaps being quite knowledgeable, to everything that's known out there in the field. How do we gather that up? And I guess I'm sort of a fan of thinking that we've got technologies for doing that kind of thing now. How can we exploit them better? I don't have the answer, but
And another thought I had, Maureen, I don't know to the extent this has changed or not, right? But I know that at least in the past, examiner evaluations were based off of final determinations, which are always issuance, right? So that's something else.
Yeah.
I don't know if that's changed. I really don't know the internal mechanism now. But if you're measuring success of an examiner by how many patents you have through, you could change that and give greater weight to rejections at some point, even though they're not final, because no rejection is ever final, to at least lessen the incentive to let things get out.
Yeah, I mean, there's all the rhetoric of patent reform debate, and I think very little of it is fundamentally asking the question, what do we really expect the patent office to be doing really for us? I think that we've gotten all off into changing substantive standards, changing first to file, post-grant review, and all these things that may pass in legislation, litigation-oriented reforms, but I still think the fundamental question about what the patent office real role
So this really looking at me. There's probably, I'm sympathetic to the idea that things that aren't useful or even morally questionable, right, that's sort of some of what Justice Story is getting at, should have some traction. And you see this more in the European system where, not that it's been successfully mounted as a challenge to patents, it's still there, and it seems to have more salience. So I'm sympathetic to it. The problem is then implementation. And so do we want the ultimate in non-democratic institution, right, the patent office, examiners who are technologists, not ethicists, not right, making these determinations? That seems uncomfortable to me. Maybe you could get some sort of ethics panel at the patent office to make these assessments, but I'm not quite certain how we wrestle with that. Congress would seem to be the institution to do it, but they are not going to be able to respond to the changes in technology quickly. In fact, and that's aside from the capture issue, that maybe they would just embrace them all, even they shouldn't. So I think it becomes a question of, and then are the courts in a position to do this? And the courts, right, read Chakrabarty, the courts expressly state, we are not in a position to make this assessment at all. So I think what's an interesting area to look at this is, I don't know where it is online now, but there was this patent application filed for a human-animal chimera, and they rejected on the basis of enablement, which is a pretty strong one, right? No one's actually made us things yet. But in the discussion by the examiner, there is this take on, this is a morally objectionable invention, and maybe that's a basis to do it, which is right, very strategic by the patent office, because examiners don't make policy. So it gave the PTO plausible deniability, right? Oh, that's just some examiner going off. That wasn't authorized by us. But I would put $1 million down that there was somebody in the patent office telling the examiner, put this in here, right, to get that conversation started. So what's that?
I think it's a commissioner himself.
Yeah, exactly. So that's the concern, right? Particularly on the moral side, you don't have a really good representative institution that can sort of reflect and have this appropriate debate. And the patent office is where those are going to come up first. So it's a little bit, and Congress reacts in weird ways, right? With the Welton Amendment saying you're not allowed to spend money on any patent that covers a human. There's uncertainty what that means, right? But it's a tough issue as we get into more technologies involved. What I read about was technologies involve issues of human identity. Do we want patents on those and propertizing that kind of thing? And my intuition is no. But again, what I came up with ultimately is we should turn to the medical side and say, right, if this is not viewed as something that's pathological, then it shouldn't satisfy utility. But I view that as somewhat a second best option, but I couldn't come up with a really effective way to do it.
You also remember that when Justice Story was speaking Lowell versus Lewis, he was reacting to an argument, there was support in statute for it at the time, that there should be a standard of commercial benefit, commercial utility, and he was rejecting that argument. So even though he includes in the rejection of that argument, all it has to do is comply with morals. It seems like maybe he injects a moral utility standard. I think the gravamen of it is that he's saying we're staying out. So I would actually say that the 19th century standard is a standard of staying out, and a case like Henry Fisher and Brenner versus Manson is a creep back in that regard.
I mean, I also think there's another type of utility question, which is more the how much utility type of question. And in some respects, that's a very hard question to have the patent office answering, because before something gets developed, it's hard to know, right? How do you know whether something could turn out to be very useful or not? But it does interact with these issues of very upstream patenting, and with the issues about some countries preferring not to patent chemical compounds. It's the same kind of idea. Because someone, discovers one use for something, does it make sense to give them exclusive rights over all uses of it? I don't know a better standard, but I do think I see the problem. So I think that it's something to, and people have tried to think about this by saying, let's raise the reduction to practice standard, so you really have to reduce something to practice, at least you have to have made something. There's problems with that too. But I almost think that's the more important utility question myself, because I agree that I think it's hard for the patent office to deal with these. I don't think I want the patent office determining the morality questions.
so one more final question.
So, as we talked about, the purpose of the patent is to create innovation. And, medicine and medical devices, it's done a great job and moved forward a ton. But sort of the dark side of that is that the limited monopoly could be blamed as one of the major players in the rising healthcare costs in America. Is there any sort of discussion or discourse going on in the IB community about the kind of conflicting goals there?
I don't think it's been on the international level quite a bit about access to medicines and the cost there. No, I haven't seen it tied directly to U.S. healthcare costs, with one exception, drug reimportation ideas. Right, go buy the drugs in Canada and bring them back in. But what was striking to me as a patent person was that the patent issue simply was mentioned, that in essence, you're encouraging people to be potentially infringing these patents, and you may be able to stop that flow. It would put pharmaceutical companies in the odd position of suing their customers a bit more, because likely some of these other actors are outside the U.S., maybe outside of the jurisdiction of the courts. And it also then begs the question of what does it mean under first sale doctrine, right? If I buy my drug in Canada, why should the U.S. patent survive? The Supreme Court was supposed to decide that in copyright this term and punted because they were equally divided with Justice Kagan recused. So the issue's percolating out there, but I haven't really seen, and others may know more than I do, a concrete discussion about that relationship between patents and healthcare costs themselves.
I think one place where this does come up is in discussions about, none of which have really led to anything yet, but discussions about whether there are alternative models to the current model for clinical trials. Because this is what raises the cost of if we're talking about drug development, is the cost of clinical trials. And having clinical trials done, by private companies raises the cost, leads them to lobby for very strong patent protection that other industries are not necessarily that happy with. And also leads to a lot of data that is held tight, held closely as trade secrets that really, from a health point of view, we might want out there better. So I think definitely people are talking about that. Some people have suggested various ways of having either government funding or other kinds of public-private partnerships. And I think more of the work on that is going on, again, in the international context, particularly to do with the so-called neglected